When Renfield saw me, he became furious, and had not the attendant seized him in time, he would have tried to kill me. As we were holding him, a strange thing happened. He suddenly redoubled his efforts, and then as suddenly grew calm. I looked round instinctively, but could see nothing. Then I caught the patient's eye and followed it, but could trace nothing as it looked into the moonlit sky, except a big bat, which was flapping its silent and ghostly way to the west. Bats usually wheel and flit about, but this one seemed to go straight on, as if it knew where it was bound for, or had some intention of its own. Now, that reading from Bram Stoker's Dracula, as you all might know, does that refer to a few bats outside of Charleston, South Carolina, that we're going to discuss today? Or does it refer to the National Environmental Policy Act and the wings of that act, which flap down and prevent housing from being built all across the country, including for over a decade in Charleston? We're going to discuss that in the Fourth Circuit and another Fourth Circuit case today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We are recording this, and this is very important, the afternoon of Tuesday, February 11th, 2025. Now, that means that our original recording, which was going to be tomorrow, Abe Lincoln's birthday, could not happen due to an impending snowpocalypse in our nation's capital, which is not where I am, which is where our main studios are, and my good friend and colleague, Ben Field, who is sitting in one of them. So we were going to have a full complement with two IJ attorneys guests. We couldn't do that because tomorrow, apparently, they're not going to be able to move around the area at all, and the snow is going to shut down everything, and there might be zombies walking around in the snow. So instead, we're doing it today, and Ben has bravely stayed at the studio where he is going to record this, and then I think he and everyone else are going to flee for the hills and try to survive this snowpocalypse. So, Ben, how are things going today? Do you have your canned goods and your shovel ready?
I do. There were flurries starting when I came into the studio, so hopefully by the time we're done, there's not 3 feet on the ground, and I'm not stuck at headquarters here surviving on LaCroix and granola bars.
Well, yeah, I mean, that's the thing. I think there's sun chips, too, right, around the office.
Yeah,
so
I won't starve.
That's so good to hear. I'm sure our audience is happy, too. Of course, our audience is going to be listening or watching this a number of days from now, and probably there was no snow at all, or it all melted within a couple hours, or whatever usually happens with those snowstorms. Although I know school was shut a couple weeks ago in the D.C. area for some people, so I won't belittle that. So we have two Fourth Circuit cases today, and as I was intimating, the one Ben's going to talk about is one of these crazy National Environmental Policy Act decisions that I don't want to belittle the interests of the animals, but often really the animals are kind of a sideshow, and what the case is really about is just preventing development. In this case, the building of some homes, which we've been talking about in recent years, is kind of an important thing. So, Ben, what's the real story here in Charleston, South Carolina?
Yeah, so I think to set the stage, it's important to realize, what the stakes are. As you were saying, building houses is important, and particularly in fast-growing communities. So, I looked up what Charleston's metropolitan statistical areas growth has been, and they've essentially been growing 20% a decade for the last 20 years. So we're talking about adding hundreds of thousands of people, and they need to go somewhere. And this case is about whether there's anywhere to put them. And it'll touch on the National Environmental Policy Act and the Endangered Species Act, and how sometimes, as you said, those are sort of used as cudgels when the real goal is NIMBYism and just stopping development. And it won't be Dracula, but it will be somewhat like The Godfather Part 2, because we're going to have an extended retrospective in the middle of our story.
Nice. How's your Italian?
Not great, but I don't know what the current tolerance is for Italian stereotypes, but fortunately, we're on video, so you can at least see me making the hand gesture when appropriate.
That was good.
So the case is South Carolina Coastal Conservation League versus United States Army Corps of Engineers. And as we've been saying, it takes place in Charleston. And there's an area that was annexed into the city that has historically been used as a timber farm. Um, and as we talk about in the YIMBY world, or in the world of wanting to build stuff, a timber farm in this fast growing area was probably not its highest and best use. So instead, they were trying to develop it into 9,000 homes, plus schools, city services, and a medical center. So lots of the housing and services that a growing jurisdiction like Charleston needs. And they started this process in 2012. Going through Clean Water Act permitting, Endangered Species Act permitting, and environmental assessment. And in 2022, they essentially had everything squared away and things were ready to go. But then things took a turn when an animal that lives in the general area, the northern long-eared bat, was added to the list of endangered species, which triggered further review under the Endangered Species Act to make sure that the bat was appropriately protected. And in general, if there's an endangered species in the area, the government can sort of create an ESA exception for the so-called take of the species, which is just a statutory way of saying everything from harassing it to killing it.
Right. Defining take is like a huge deal in these cases sometimes.
Exactly. And it really is all manner of sins. Anything you can do to the bat that the bat doesn't like counts as a take. But in general, in Endangered Species Act cases, you need to, if you're going to allow some takes for a particular project, you need to define at the number of specific animals that will be taken. But that's not actually particularly feasible in this case, because it turns out that this bat has never actually been seen on the property at issue. And it's sort of, it's a bat. It flies around, as your poetic introductory quote suggested.
Flips, usually.
Exactly. So they don't really stay in one place. So in situations where it's not feasible to do the individual bats or individual animals, then you can come up with a proxy, which in this case was the number of disturbed acres. And after this review, the government said, okay, we're going to impose some conditions, so you can't take down trees at certain times of year when the bat is going to be at its most sensitive, and other conditions like that. You have to put up some artificial habitat to replace the trees that are being taken down. But the government said, if you do all those things, we are convinced that the bat will be well taken care of. And then what happened at that point is what always happens at that point, which is that a group of friendly neighborhood conservation groups all filed a lawsuit seeking to enjoin the project and demanding that there be yet further years of environmental review. And so I'm going to put a pin in that, and we're going to do our flashback to the 1970s.
Whoa.
And to a very famous case called Tennessee Valley Authority versus Hill. In this case involves another critter called the snail darter. And if you don't like bats, I think that the snail darter is an even less romantic species. It's this tiny little fish type thing that lived apparently in this one lake in Tennessee that was going to be flooded when the Tennessee Valley Authority was building a dam there, the Tellico Dam. And a local conservationist and naturalist discovered that there was this special type of darter that only lived in this one lake and stream that was going to be flooded, and he successfully had it classified as a species. And because this was the only place it was endangered. And the dam was about 80% complete when this litigation took off, and the Court of Appeals in that case enjoined the completion of the dam. So while the dam was being built, Congress passed the Endangered Species Act. It didn't really have exceptions at that point. So if a project was going to harm an endangered species, it pretty much had to be stopped. And it went up to the Supreme Court to say, like, is that really, you mean that? Like, this dam that's 80% done, we just have to stop it? And it's a very famous case in sort of the textualism canon and the shift from the Warren Court to the modern court, going from more purposive interpretations of statutes to more textualist ones. Because it was a case where, all of the purposive arguments, it seemed ridiculous that you would stop building this dam in order to save this, tiny little species that nobody really cared for.
Right. But the text was pretty clear.
Exactly. The text said, nope, it's an absolute prohibition. And, there were other purposive arguments like saying well, Congress kept appropriating money for the dam and they wouldn't have done that if they didn't expect you to build it. And the court said, be that as it may, they also passed the Endangered Species Act, and we're not going to read these appropriations bills to impliedly repeal the Endangered Species Act. And it's a case where, it's unanimous opinion and, conservative justices in the majority, probably going against their policy inclinations. And so it's held up as this great case showing what real textualism is, and that if you just follow the text, maybe you'll sometimes end up in some weird places, but that's the way to do it. And as it turned out,
we called it the dam case in legislation class.
And another fun thing about the 70s is that, back then Congress passed laws. So actually in response to this, Congress passed a law exempting the Tellico Dam from the Endangered Species Act. And then over the years, they added additional exemptions like the ones that are at issue in this Fourth Circuit case, so that it was less ridiculous a barrier. But this actually has been in the news recently because in January, the New York Times had this small bombshell expose. At least it was a bombshell expose among folks who are interested in property rights, that it turns out that this snail darter was never actually a distinct species. And more
I think that's been known for a long time, but it was more powers that be were admitting to it or something.
And it's always been suspected, you're right. But there was this splashy New York Times story about it, which, got into sort of the internecine fights within the conservation world, and that you've got some people who really, really want to find new species because it's a way to block development because now they're endangered and you can, wield them as a cudgel. And other people who don't want to do that, they even have names for them. I think it's splitters and lumpers are the two categories. And apparently if you're in this world, to be a lumper is a terrible term of derision because you're taking away species that can be used for environmental litigation. And obviously this was a story that flattered, libertarian sentiments or property rights sentiments. But I dug a little bit further than that. And a well-known practitioner named Adam Unikowski, who has a great legal blog, very creatively called Adam's Legal Newsletter. He actually did an extensive Substack about this, where he actually has a scientific background and read the relevant studies with some help from AI. And so he had a more benign take, which was that actually in the 70s, it was a legit, it was an understandable position because back then you just had to look at these little darters they're just tiny little things and compare tail lengths and things like that to see whether they were distinct species. But now we have much more sophisticated genetic testing to really get into this. And so his take was,
well, no, you give Adam's take.
Right. His take was that this was the New York Times was telling this story about this battles within it, and his take was that it's really more of a sign of scientific development, and that we now just have better ways to tell how different species are.
That's it. No, aside from endangered species stuff, that's a huge debate these days amongst geneticists and biologists. That is a species. Can you interbreed then not a species? And that would mean a lot of things we think of as separate species, like say lions and tigers, wouldn't be separate species because they actually can interbreed in a lot of these different animals. So how you define how you define a species is not actually a super scientific basis. There's a huge amount of gray area there, and I can see how that changes with scientific progress, and then it interacts with public policy.
Right. And the Endangered Species Act doesn't have a particularly precise definition, so
Right.
it really is up for fighting. Adams, his newsletter, the Substack actually gets into this. Like sometimes you'll have species A that can breed with species B, and species B can breed with species C, but A and C can't breed. Is that close enough? So
Right.
it is a big debate. But going back to the Fourth Circuit in Charleston, I think what you see how these issues are actually wielded. So we've got this piece of property that's currently a timber farm. It's going to be turned into homes and hospitals and schools. This bat has never actually been seen on it. And yet, even so, it's gone through 12 years of environmental review, but that's not good enough for the conservationists. And they're wielding this bat as a way to shut down the development.
Big
And
bat.
yeah, exactly. And they kind of have a point if you think about it, because there's actually another Fourth Circuit case involving the same bat, but from a different area, where the Fourth Circuit struck down the use of one of these proxies in place of, you actually counting the number of individual bats that will be taken. And so the conservationists say, bada bing, bada boom, that's it. Just to go back to our little Italian. Unfortunately, we didn't actually do much Sicilian stuff in my flashback, so we'll have to do it there. And they say, this case is on all fours. It governs. That's it. And what the Fourth Circuit says is, at least in this preliminary posture, because here we're in the emergency injunction world where the district court gets a fair amount of discretion, says, well, the district court actually dealt with that. And the district court explained that in that other case, you had it was unique circumstances where it was a pretty small area of land. It was right near where these bats hibernate, which makes it much easier to count them. And so in that situation, it would have actually been pretty easy for the government to count the bats, and so they couldn't use a proxy. But in this situation where there isn't one of these hibernation areas nearby, the bat is never really, hasn't even been seen there. The government it's a much larger area of land. The government has a much stronger case that it can't individually count the bats, and therefore it's reasonable for them to use this proxy. And so they say it's fine. And then, as you mentioned, there's also this National Environmental Policy Act claim in there, which is playing second fiddle in this case. But basically, the argument there is that, well, the government did an environmental assessment, but the conservationist said, no, they should have done an environmental impact statement. And I think that this is an example of the kinds of problems with NEPA litigation, is that everybody knows that nobody actually cares about what's in the EIS versus the EA. Having another 1,000 pages of paperwork isn't going to change anything. Nobody's actually going to read it anyway. It's entirely about slowing down the project. And these cases are kind of frustrating because every single one of them, no matter how it comes out, it starts with the court saying, NEPA is not a substantive statute. It's a procedural statute. We're just supposed to evaluate whether the government took a hard enough look, but we don't consider the substance of the decision. But then it goes either way. Courts that go in for the conservationists say, or the NIMBYs or whoever is challenging it say, oh, well, you could have, if you had added another 100 pages of studies, you would have, been able to more evaluate these issues in depth. And it's always possible to point to something that they should have studied.
Right.
But the court here takes sort of NEPA's general deference seriously and says, no, they explained why they thought the environmental assessment was sufficient and an EIS wasn't. Lots of people were consulted, and the only person who asked for an EIS was the lead plaintiff in this case. And in light of that, we think that they took a close enough look, and that 12, at least for purposes of this injunction posture, 12 years of environmental review is enough.
Right. And so going forward, so this was all on a preliminary injunction. It'll go back down. They'll, I guess, go forward. But I mean, I would think the record is all pretty much done because of all this environmental review that's been done. So they'll kind of get to a final judgment, but likely it's not going to be very different. And then they could appeal that. And I mean, the writing on the wall seems that's not going to be very different either.
Yeah, I think that's right. And obviously the real action is, in these cases, is getting the TRO or the preliminary injunction, because the goal is to stop the development.
Right.
Once everything is built, it's hard to. A court is not going to order them to tear down a hospital that's already been built
and plant all the trees and
Right.
bring back the bats.
Notwithstanding TVA versus Hill, I don't think that would be a successful lawsuit for these conservationists.
Well, it seemed I don't have too much to add to your brilliant overview there, but it seems to me that this demonstrates the discretion that the government has, because you could see a different set of bureaucrats who would review all this and would say, well, if we spend a little bit more time looking for the bats, then maybe we're going to be able to make this work. And so we're going to have to go in that direction. And that means that you won't be able to develop this thing for, years and years or what have you. And that could be challenged by the developers. But then the court's going to, say, well, you have a lot of discretion here that we give to the government. And, I'm not a scientist, so I'm not going to review all that. And so, yeah, you can't develop it yet. I mean, it kind of seems like it's going to go one way or the other, not maybe based on the science, although it seems like this kind of is in line with the science, but just based on what the bureaucrats come up with.
Yeah, I think that's right. And I mean, to a certain extent, that's sort of the nature of the beast, that these are discretionary calls. How much harassment of the bats is too much?
Yeah.
And how do you trade that off with other considerations of what's actually feasible? And so I think the question, to a certain extent, the problem with NEPA and Endangered Species Act litigation is just that when you add in the litigation on top, and now you've got these non-expert judges weighing in on top of the agency, you're just multiplying the number of veto points, and making it very difficult for a developer to predict what's going to happen.
Right, because I mean, it's kind of amazing. This developer hasn't run out of money to do all this in the 14 years or so that this process has been going on. It's a huge development. It sounds like acres and acres of homes and businesses, so they're probably going to make a lot of money off it. Maybe that's allows it to go forward. As a final point, I'd say that this is an example of how there is, despite all the gloom and doom from certain quarters, when the Chevron case was overruled recently by the Supreme Court, which now means that federal courts don't have to defer to agency interpretations of statutes. There's still all kinds of deference to agencies, the whatever the study was, the studies were here. And so that's not going away. As long as you have big agencies, courts are going to want to defer to them because, wow, that looks really hard, figuring out all the science about bats. And the law says they have to look at the bats. And so it's going to happen. It's just not going to happen in the same way. Charleston is a beautiful town, by the way. It has lots of forest around it. My family and I went there a couple of years ago, and we looked at one of those plantations nearby in the forest. I doubt that's probably what's being developed here, but it was very pretty. Shout out to the Graham family of South Carolina, who are developers in the Charleston area, and are very very pro YIMBY. So I don't know their thoughts on this case, but they're very pro YIMBY overall. So we're going to move on from exciting bats and environmental review and building homes to something in some ways much less important, but very important as to how our federal court system works. Federalist system, I should say, with state and federal courts. So this is a kind of case we don't usually do here on Short Circuit, but I think it will be interesting, especially to two sets of people. One is specialized appellate practitioners. We know some of you guys listen to us. You're going to like the nuance of how this appeal went. That's in the Fourth Circuit. But also people who aren't even lawyers but listening to us, but like to learn some of how the court systems work and what it means to be, say, in state court or federal court. I think this might put a little flesh on the bone to some of the mystery that goes on, that seems to go on behind the scenes in some litigation. So this case is a small slice, very small slice of a huge thing that's been going on in the courts the last few years, and that is litigation regarding the opioid pandemic, or whatever they call it, all the opioid addiction problems. So there was a case at the Supreme Court last term about this massive bankruptcy with a pharma company that was making a lot of the opioids that people were taking too much of. There's all these doctors involved. The book that we talked about last week, that just came out, that we had the author Rebecca Hall Allingsworth on. She details a lot of the licensed Tennessee doctors who would overprescribe opioids. So there's all kinds of litigation about the opioid stuff. And this is a small part of it where the city of Martinsville, Virginia, which, if you're wondering where that is, it's actually very southern Virginia. So it's not like Ben's area of Virginia. It's going to take him a long time to get there. Kind of in the shadow of the mountains, really close to North Carolina. And Martinsville, Virginia, population 13,000 or so, they thought that they had a claim against some of these pharma industrial complex folks. So filed all this litigation, filed it in state court, basically saying, we've had expenses that we've had to suffer because of the opioid crisis and all this overprescription, and so we want some of our money back. Well, the case was removed from state court to federal court. And it was all, big pharma were defendants and other coordinated players. A lot of those claims stayed in federal court, but some were remanded. And so what does remanded mean? So you start a case in state court. Sometimes cases can be in state court or federal court. In fact, most federal cases could also be in state court. They just happen to be in federal court. So if you have like a civil rights action under federal law, or you just have some other federal claim, or you're diverse, so citizens of two different states, but you're suing about enough money, you can be in state or federal court. So if you start in state court, but it could be in federal court, you do this thing called a removal. And all that, to do that, you just file paperwork in federal court, and hey presto, it's in federal court. But then the defendant, who doesn't want to be in federal court, maybe, the plaintiff, who doesn't want to be in federal court, they can say, hey, actually, this doesn't belong here. This isn't really a federal claim or what have you. And so then they argue to the federal court, hey, put us back in state court. And that is called a remand if it's put back in state court. So this case originally was removed and then remanded. Then 5 years go by, and some of the time it stayed, some of the time there's stuff going on in state court. But for whatever reason, the defendants, who at this point are two pharmacy benefit managers, PBMs, Express Scripts is one of them. Now, pharmacy benefit managers we have talked about in a previous short circuit. I think when my buddy David Asp was on a couple of years ago and we did an ERISA case. They are like kind of the tubes of the pharmaceutical industry. So you have your pharmacist, you have big pharma who make the drugs, but the PBMs do a lot of the work to like get drugs to the right places and to get payment made. They are defendants, apparently, because they're part of all the distribution of these opioids, but they argue that they should be in federal court now, not because of diversity jurisdiction or a federal claim or anything like that, but because they claim that they are federal officials. And you're like, federal officials? Well, yes. So a couple months ago, we did one of the cases. All these cases, I think, are, I don't know if they're going away. Maybe these ones are still around, but the Georgia state criminal prosecution of all the Trump folks. So Mark Meadows was one. There's a few others. The whole Fannie Willis thing. So that was in federal court because Mark Meadows, as a federal official, said, "Hey, I can move this case to federal court." And then it went up to the 11th Circuit, and they actually found he shouldn't be in federal court. So it's the same statute, the exact same statute that Express Scripts is saying, "I'm a federal official." How is Express Scripts a federal official? A pharmacy benefit manager, because they argue The statute is supposed to be interpreted very broadly. Supreme Court has said that. And they had the Department of Defense contracts. So a lot of servicemen, getting opioids through their prescriptions. And they say under that, we actually are official. And it's not crazy for them to argue that. There's other cases around the country that are adjudicating the same thing, like through maybe Medicare contracts or Medicaid or what have you. In this case, it was Department of Defense. So they say we should be in federal court. Okay. So the city of Martinsville say, no, you should not be in federal court. That's too much of a stretch. So they move to remand. And the federal district court says, you know what? You're right. This is for the second time, we're sending this case back to state court. Now, usually that's the end of the line. We haven't, over the years, talked on Short Circuit many times about the courts of appeals discussing whether you can remove a case or not. I mean, it happens, but not a lot. And that's because usually, unlike most things in the courts, you cannot appeal a removal, a remand decision. So when the federal district court says back to state court, that's the end of the line. If you're there for, say, diversity purposes, you're done. One and done. You just get the one shot. But there's an exception. There's a couple exceptions. One is for certain kinds of civil rights cases, and one is for federal officers. So, okay, well, we're saying we're federal officers, so we're going to appeal. So 2 days after this order comes down, they appeal. Now, they also ask, and it's denied in the actual order by the district court, to stay their ruling so they can appeal and then have the case not go to state court in the meantime, because then that would get rid of their appeal. Well, the district court denies this. Now, denying a motion to stay what's going on in the district court is pretty normal, or like the worry about whether you can stay it or not. It happens all the time. Like a very straightforward example. Say you get a judgment against you for $100,000 and you're in federal court. And you're appealing that. You're a defendant. You don't want the judgment against you. But in the meantime, you also need to stay the judgment. And usually you have to post a bond or something like this. If you don't move the stay of the judgment, if you just go on your merry way and appeal to the Court of Appeals, the plaintiff, even though the appeal's going on, can use the judgment to like seize your bank account and get the money for himself. And then you're meanwhile trying to reverse the judgment that he already has the money for. So it's a very ordinary thing to try to stay that judgment. So they were denied the stay. But the court said, look, I'll stay it for 30 days because that's a pretty normal thing for almost any ruling in the federal courts. But then I'm sending it back to state court. So they appeal. The appeal runs its way. It takes a while. And a little over 30 days after that, they mail the order to state court. So where is the case at that point? It's mailed to state court. For a normal remand, that means the case is in state court. And the Court of Appeals does not have jurisdiction. It doesn't exist there. But the statute specifically says they can appeal. It doesn't say they can appeal if the district court then stays its judgment. It says they can appeal. So what happens? So that finally brings us, which I will talk about very quickly, to the actual opinion, which is not technically like an opinion on whether they can be in federal court. So on the federal officer stuff, it's on the immediate question of whether they needed a stay or if the case actually is technically now in state court and they can't do anything. And two judges, the majority, think that, the case is properly before us in federal court. And the dissent, that judge would say, you know what, Judge Wynn would say, actually, we have no authority to even be talking about this right now. So it all turns on the interpretation of a case called Coinbase from the Supreme Court. That's a very recent case, which had to do with cryptocurrency, which I don't understand, but it had to do with arbitration agreements about cryptocurrency. So arbitration says, I'm in district court, and I say, look, we shouldn't even be in court. the contract says we should arbitrate this. So I moved for the court to send it to arbitration, and the court says, no, I'm not going to do that. So the party in that case said we should be able to immediately appeal this, and not have to waste our time in court, because the whole point of what we're trying to do is get it sent out of court anyway. And the Supreme Court said, yes, under the Federal Arbitration Act, that is true. Now, on the other side of this, there's case law about moving to stay, right? The thing about the judgment and the $100,000, that's black letter law, that you have to move to stay judgments. If you appeal, it doesn't mean the court can't do anything with the judgment. And those two precedents kind of run against each other. And so what the majority says, Judge Richardson says, is that under Coinbase and the implications from that, and this older case called Griggs, they call it the Griggs principle, which it makes out to be this really important case from 1982. And then the dissent points out it was a per curiam opinion that, maybe isn't all that famous. But in any case, they said under the Griggs principle, when you appeal a case, the district court doesn't have jurisdiction over that issue anymore. That's kind of how it works with an appeal. It might have jurisdiction about ancillary matters, like maybe enforcing a judgment or awarding attorney's fees or something like that, but not the heart of what's being appealed. And so because of that appeal, the heart of what's being appealed, the remand, can't happen. So it doesn't matter that they later mail the piece of paper to the state court. That has no effect. And so the implication is really they didn't need the move to stay. It's an automatic stay by appealing. The dissent says that doesn't make any sense. Everyone understands that you have to move to stay thing. It's very specific when it's an exception, and that Coinbase case really is just to be read about the Federal Arbitration Act, and so it doesn't. It does matter whether or not the district court gave the stay. So why am I talking about this? Why is this important? This probably will affect a lot of litigation, whether you can argue about remands or a lot. There's all kinds of cases where the defendants are desperate to get out of state court and get into federal court. And federal officer if these pharmacy benefit managers can credibly argue that they're federal officers. I mean, to me, it sounds pretty nuts. They can be federal officers. But if they have a colorable argument for that, there's all kinds of other entities out there that could be federal officers, because there's all kinds of federal contracts on God knows what. And so they can make these arguments too to stay out of state court. So this may be something that the Supreme Court is going to have to clean up soon, even though it sounds kind of like quirky and a one-off thing. I will say I kind of don't get this is an example where maybe Congress has done different things in different times that contradict each other, a little bit like the Endangered Species Act and the dam that Ben was talking about a little bit ago, because the statute itself says an order remanding a case to the state court from which it was reviewed is not reviewable on appeal or otherwise, which Congress doesn't do that very often. So you just can't appeal this. But then they say, except that an order remanding a case to state court pursuant to federal officer jurisdiction and the other exception shall be reviewable by appeal or otherwise. So they're explicitly saying this exact thing you can appeal, which Congress also doesn't do very often. But how could you not do? Then you could not appeal if your district court denies your motion to stay. You would just be at their grace, because then after 30 days they're going to mail this piece of paper and the appeal and the case in federal court goes away. So I seem to think that the majority is right here, but I don't know if they did themselves any favors by leaning so much on this Coinbase case. And I see this as starting to create a bit of a mess in appellate procedure jurisprudence, and we'll see if it gets sorted out. Ben, you used to worry about huge corporation clients like this. Does it bring back any memories to you or give you special thoughts?
Yeah, absolutely. I mean, I think that this is, lawyers often say that like procedure can trump substance, and often that is the case in this kind of removal world. And you have, after the financial crisis, everybody was suing people who issued mortgages. There's still asbestos litigation going on from decades ago, and a lot of times the forum that you're in is, if not dispositive, at least dramatically affects what the plaintiff is going to get. And it's kind of a dirty little secret within the judicial system. And it's not for, I mean, obviously depending on what, you can tell stories both ways, but it's a world where, I won't talk about the specific courts involved here since I don't know them particularly well, but canonically, plaintiffs in these types of cases want to be in state court, where you can imagine like if a town is suing a PBM over opioids, a local judge who is elected by the people in that town, who are the same people electing the city attorney bringing the case, is probably, it could very well be favorable, and the jury pool that like is pulled only from that town might give a very, very large verdict.
Yeah, they might all have relatives who have been involved in this stuff, and
exactly. And so the plaintiffs would, right, and so a plaintiff's lawyer would say, yeah, that's exactly what our jury system is supposed to be, where like the community is weighing the claims. The defense would say, well, yeah, they're letting emotion get the better of them, and if we could be in federal court with a judge with lifetime protection, and who is drawing from a broader jury pool that will be more neutral, we're going to get a fairer shake. And you see this, settlement amounts reflect that, certain jurisdictions, if you're in the court there, it's going to be better for you, and it's more risky for a defendant to roll the dice going to trial. And so this has been happening a lot. Like, at least within the last couple of years, the Supreme Court has intervened in climate litigation coming out of state courts, where BP and other oil companies want to remove to federal court, and they come up with a bunch of creative theories like this officer removal doctrine. And I think like the fact that people are coming up with these clever theories and that these issues keep being litigated is just indicative that the forum can often be as important as the law when it comes to what the ultimate outcome is going to be.
I think I've said on this show in years past that I was astounded when it came up in this Fonnie Willis stuff in Georgia, that those defendants might be able to get to federal court. And our friend Andrew Fleischman in Atlanta kept telling everyone, and eventually he got in the New York Times about it, that they might be able to do that. And all of us were like, what? And it's this statute, and it's federal official, and it's read super broadly, because the original reason for it is they didn't want to get federal officials getting stuck in state court, and perhaps in the post Reconstruction South, where you have a federal official who's maybe doing civil rights work and is like stuck in some podunk little kangaroo criminal court, and they want to be able to allow him to get into federal court to get a fairer forum. And so that's where this history comes from. But now it's gotten to the point where, BP and the pharmacy benefit managers are federal officials. I don't know if BP has claimed to be a federal official, but
I think they had a federal question type of argument.
Yeah, I think
interfering with the entire energy economy was like so destructive that it necessarily raised a federal issue. If you'll permit me one brief diversion, I think my favorite sort of forum battling example comes out of the Federal Energy Regulatory Commission and pipeline litigation. So essentially, whenever FERC decides something, or sets a rule or something, the energy companies will all sue on one side, and the environmentalists will all sue on the other side, and they all have their favorite court. So, in general, energy companies want to be in the Fifth Circuit, which is, more conservative. It's Texas, Louisiana, Mississippi, more friendly to energy. And then the enviros want to be somewhere like the Fourth Circuit, which is, has at least recently been a majority Democratic appointee court. And so there will be a decision. Everybody will sue instantaneously across the country. And then they literally have a lottery.
Yes,
where
we've talked about that recently.
A clerk will pull a circuit out of a hat or something
it's
like that.
It's a ping pong ball.
A ping pong ball. Yes,
It's in
you're
the
right.
rules. It has to be a ping pong ball machine.
Which is one I find delightful, and two, a repeat guest and friend of the show, Sean Murata, who was a colleague of mine before I came to IJ, sort of had a niche part of his practice, which was figuring out the ideal way to game the system to try to get yourself in the most favorable court.
Yeah, my biggest disappointment about that is they don't live cast it. It's done in a clerk's office somewhere, so you can't watch it. But I love that Sean is world famous for knowing how the ping pong ball mechanism works. So, well, that's great that we got to talk about the ping pong ball machine once more. And also, some of you know a little bit more about how a case goes from state to federal court and vice versa. And some of you know a little bit more about bats in Charleston, South Carolina, and also the snail darter. So thank you, Ben, for taking us down that Sicilian saga. We will, back to the 70s, we will maybe update folks later how you're doing snowbound in your cabin that you're heading to now. But in the meantime, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.